Yes, Ms. Mohammed.
Thank you. I have a couple of submissions to make. If I'm allowed, may I direct the Commission to page 12, paragraph 6.1 of the founding affidavit of Mr. MOGOTSI. Chair, paragraph 6.1 gives a picture of what happened when Mr. MOGOTSI reached out to the evidence leader. And he says that it was around that time he did not have any attorneys, which coincided with the time that Mr. Suleiman was giving testimony in the commission. Now, he also further in the next paragraph says that there was an exchange of WhatsApps and telephone calls, and the content of the conversations caused him grave concern regarding the evidence leader's impartiality. Now, it goes on and he explains what then transpired. What is important, Chair, is that with regards to the call that took place on the 9th of March, the response from the evidence leader is that he does not have any recollection of what the content of the conversation was about. And therefore, it cannot be that what he says is most probably true as opposed to what Mr. MOGOTSI is saying. Mr. MOGOTSI gives a thorough explanation as to what was discussed when the call took place, and that is the evidence that we have before the commission, and it's not disputed. Now, Chair, I also submit that it's important that we visit the purpose or the rule of one being an evidence leader when it comes to commissions. The evidence leader's role is crucial in its nature, in that it will decide how the evidence is tested and it will shape the lines of questioning. And it ought to be done in a way that can assist the commission, and it also impacts on the fairness of the procedure. The evidence leader can influence the narrative of the evidence, and he's the one who engages with the witnesses in order to solicit evidence from them. Now, Chair, the test for what constitutes apprehended bias is whether a reasonable, objective, and informed person would reasonably think that the decision maker or relevant actor...
Are you going back to that test now? Because I thought right at the beginning, you and I reached a stage where we agreed that that's not the correct test, and that test applies to decision makers, and that an evidence leader is not a decision maker.
I'll retract.
Yes.
I'll retract that statement, Chair.
Without interrupting you, because you're dealing with an important point. The evidence leader does not say he does not recall that phone call of 2056 on the 9th of March 2026. on page 82 at paragraph 17, this is what he says. I have no detailed recollection of what was discussed. And then he continues, but in paragraph 19 on page 83, he then sets out what was discussed. And you find that on paragraph 19, he says, in our call at 2056 on 9 March 2026, this is what happened, and goes into detail about that. And then on 84, paragraph 23, he says, I would never have encouraged Mr. MOGOTSI to give false evidence against Mr. Karim. I categorically deny. Then he sets out the denials. And then he says the impression Mr. MOGOTSI is trying to create, where reference is made to help, deals with that in paragraph 24. So he doesn't say he has no recollection of the phone call. So that's the full answer to that. So maybe you can then continue with your submissions. I just wanted to draw your attention to what the affidavit actually says. But by saying he doesn't have a detailed
Commissioner, the evidence leader says in paragraph 17 that he does not have a detailed recollection, meaning that he cannot recall specifics regarding the contents of what was discussed on that day. And Mr. MOGOTSI then says, I called the evidence leader, and the evidence leader suggested that based on the evidence that Mr. Suleiman gave, he threw me under the bus and I need to defend myself. That in itself is a dispute of fact. He says in paragraph 6.3 that the evidence leader asked him to get anything against Suleiman and he will help. And that Mr. Suleiman had implicated him and that he should find a way to defend himself. And further, that Mr. Suleiman was lying. Now, these are two conflicting versions of what the contents of the telephone call are that took place on that day. And my submission would be, in light of the absence of a detailed recollection, then what would be of sense is that Mr. MOGOTSI's version as to what was said on the day should be the one that stands.
There's a specific denial in 23.2. I deny that I suggested that if you could find evidence to implicate Mr. Karim, I would protect him from adverse findings from the commission. So that is a specific denial, and it goes to the very issue you are raising.
You in one breath, Commissioner, say that you don't have a detailed recollection, and in the same papers you say that you deny. How do you deny something that you cannot recollect in detail?
But that's a simplistic approach. Let us take the example of a person and their child. And the child says that on the 26th of April 2021, I had a discussion with my father about issue X. The father says, because of the time that has since elapsed, I do not remember that conversation. But there is no way, with the parenting skills that I have and the values that I cherish, that I could ever have said something like this to my child. I would never, ever. The parent knows what the values they cherish are. The parent knows what they could never, ever say to their child on the basis that it would be at odds with their values. So the parent, even if they do not recall the conversation referred to by the child, is in a position to say, I could never ever have said anything like that to my child. I see nothing wrong with that at all. And that's basically what, in substance, of course, that's what Commissioner Khumalo is drawing to your attention. So the chief evidence leader is saying, whatever the detail of the conversation might have been, there is no way that I could ever have said to Mr. MOGOTSI, do the improper. I see nothing wrong with that. He may not remember the detail of the conversation, but suggesting to Mr. MOGOTSI that he should do something improper, he said, that I could never ever do. So I see nothing wrong with that. And your point about him in one breath saying this and in another breath saying that does not necessarily apply or necessarily make sense. Do you follow my point?
I hear you, Chair.
Yes, yes. I had said we would try to, or rather not to interrupt as much as possible, but sometimes we cannot resist it because of the submissions being made, because we want to give you an opportunity to argue your case as freely as possible. Yeah. Please continue.
Thank you, Chair.
The selective investigation of the selective leading evidence.
I'm no longer inviting you to respond to what I said. I just want you to continue with your submission.
I'll do so, Chair.
Yes. I think before Commissioner Khumalo put a question to you, you were at a point where you wanted to deal with the role of an evidence leader in instances like these. I thought that's where you were. And I sort of assumed that perhaps you were going to take us to what Justice Nugent said in the SARS Commission or something like that. Maybe that's not what you had in mind, but once you started saying something about that role, I thought of what Justice Nugent said in the SARS Commission, in his judgment in the SARS Commission.
I will revisit that, Chair. I deviated from my chain of thought. I'm just recollecting. If I may be so permitted, Chair, may I take the commissioners to page 21 of the bundle? It's still the founding affidavit of Mr. MOGOTSI. And these commissioners will be in reply to the selective evidence that the evidence leader deals with, and this is the basis for the fear of where the bias might emanate from. If the commissioners look at paragraph 10, the applicant makes a reference to credible information that he had made available to the evidence leader and the leads thereto. And his take is that these issues, which he sees as important issues, have not been given sufficient investigative attention. And what is happening is that the interest has been directed towards specific individuals, and in brackets, it reads Suleiman. And further thereto, there's also evidence that came to the commission regarding the purchase of certain properties in the name of private individuals, and that has also been overlooked. And he further requested that these leads that he gave be given sufficient attention. And his take is that the individuals are not as significant or as important as this evidence that he has brought forth. Further, commissioners, there's a point in limine that was raised, and this the commissioners will find at page 260 of the bundle.
260.
260, Chair.
Maybe before you start on 260, can I just to make sure that I understand what is this the submission or the argument about paragraph 10? Are you saying, is Mr. MOGOTSI rather saying that the failure, there is a failure, firstly, one, there's a failure by, is it the evidence leader, because this is an application to recuse Mr. Chaskalson, by the evidence leader to pursue his allegations that crime intelligence has brought properties, crime intelligence transactions, his evidence about a section 252A operations, informant-related issues, and procurement irregularities. Is the case being made that Mr. Chaskalson has failed to investigate those, and that failure has created an apprehension that he is biased against Mr. MOGOTSI? Is that the? Okay, all right, thank you.
Please continue.
I apologize. I was directing the commissioners to page 260 of the bundle, and this deals with a point in limine that were raised by the applicant in the application for recusal. Specifically, it deals with the answering affidavit that was deposed to by the attorney, purporting to be acting on behalf of the second respondent. There is no dispute that the attorney may be authorized to act on behalf of the commission. The dispute here is that the attorney goes beyond the scope of the institutional representation and purports to make factual averments on behalf of the first respondent, defend the personal conduct, intentions, and state of mind of the first respondent, who's the evidence leader. And they respond to allegations concerning private communications between Mr. MOGOTSI and the evidence leader. This attorney does not allege nor annex any proof that he or she has been authorized by the first respondent to depose to the factual matters on his behalf. The allegations that are raised against the first respondent relate to private WhatsApp communication, telephone conversations, alleged discussions, and alleged assurances of help or protection. The first respondent's subjective intentions and conduct, those are matters that are peculiarly within the personal knowledge of the first respondent. And the deponent, who is the attorney, will not be privy or cannot comment on these issues. Now, the affidavit of the first respondent has also been presented as an annexure. And there's certain value between an affidavit and an annexure. An annexure is merely a supporting document. And the attorney cannot make a case for the evidence leader and have the evidence leader's affidavit come in as an annexure, which seems to be confirming submissions by the attorney for the commission. I'm inviting the commission to find that when it comes to the affidavit that was deposed to by the attorney for the commission, that the commission finds that that affidavit does not enjoy locus standi. The issues that are contained in that affidavit and the comments cannot be of any value or any benefit because it's comments that they know nothing about. It's personal communication between Mr. MOGOTSI and the evidence leader. And it's issues that the evidence leader should be answering and not the attorney. Commissioners, there has been an explanation that was proffered in the replying affidavit regarding these deleted telephone calls or emojis. Now,
I'm sorry. Please don't forget the point
where I was, yes, Chair.
you were about to make. In the context of hearing the testimony of a witness, and in fact, even beyond that, the applicable prescripts say that the rules of evidence that apply, for example, in courts of law, do not apply to commissions of inquiry. Commissions of inquiry may receive evidence of variety of forms which would ordinarily not be admissible in courts of law. But as I say, that's in the context, or that's provided for in the context of the commission receiving evidence towards the investigation that it was set up for. That's the context. Would you say that those rules with regard to the admissibility, acceptance of evidence would not apply to an interlocutory process like the one we have before us now? You would have that permissive manner of receiving evidence in the context of receiving evidence towards the investigation, but have a very restrictive process when it comes to interlocutory matters that relate to the Commission's investigative process. I'm asking that in the context of the point in limine that you are raising. Wouldn't there be an anomaly if that were to be the case?
Chair, in the normal route, that would be an issue to raise. However, in light of what you are saying to me or what you are putting to me, I'll submit that in a quasi-judicial tribunal like of this nature, then I cannot take that point in limine any further. If that is then the status quo, I will have to leave that point in limine and not argue it any further.
Thank you. I did not want us to reach a situation where, for example, we decide your point in limine along the lines of what I've raised with you without offering you an opportunity to respond. Well, I have offered you that opportunity and you have responded. You may go back to the point I asked you not to forget.
Oh, yes, Chair, thank you. Chair, I was making a submission with regards to the deletion or the alleged fraudulent deletion of conversations in the WhatsApp records. And I was further saying that Mr. MOGOTSI did respond to those allegations that were put forth by the evidence leader. And at paragraph 41, which will be at page 267 of the replying affidavit,
yes.
Mr. MOGOTSI says that he admits that he deleted the message dated the 11th of March that was sent at 11:29 a.m. And the intention was not to mislead the commission, as at the time he had not even contemplated bringing the application here in. He further says in the next paragraph, the sole intention behind the deletion was to protect my conversation with the first respondent from third persons. The next paragraph, he says that he admits that he deleted the calls on the basis that at the time of taking the screenshots for purposes of this application, he did not find them relevant. And furthermore, he's further to allow me to take screenshots of the relevant facts. I therefore deleted them. I understand this, Chair, and I'm subject to correction to say that to allow me to take screenshots of the relevant facts, his headset doesn't allow him to take screenshots. I'm uncertain how to read this, and I seek the guidance of the commission.
No, just make your submissions.
I submit that.
There's no need for guidance from us on this.
I submit that, and subject to correction, that his handset did not allow him to take screenshots of the relevant facts. He therefore deleted them. The calls that have been deleted were unanswered and therefore hold no significance to the application.
Except, of course, that they may assist in the context of what I engaged you on right at the beginning. I will not repeat that. Please continue.
Sure,
that is the point I made about based on the number of calls, who appears to have sought out whom in that context? Please continue.
Chair, what is common cause is that, yes, there was communication between Mr. MOGOTSI and the evidence leader. And during those conversations, a discussion came in regarding Mr. Karim. It's also common cause that during the conversation, there was an agreement or a request to bring certain evidence to rebut what was put on record regarding Mr. MOGOTSI, to defend himself, and if the need arises, to throw Mr. Karim under the bus. Now, Mr. MOGOTSI's evidence is that the communication between himself and Mr. Karim formed an impression that his cooperation in providing information against another witness was linked to his treatment in the proceedings. And this, Chair, will find at paragraph 7 of the replying affidavit. And he further says that whether intended or not, such perception undermines the appearance of impartiality. Now, it goes back, Chair, to whether or not a reasonable, objective, and informed person would apprehend bias. Now, with what had transpired and with Mr. MOGOTSI due to come back to the commission and testify, and him not being able to have provided any information that was helpful because the meetings never happened, he became fearful of appearances of impartiality, and that he would, upon his appearance, be treated unfairly.
Norman, is it not opportunistic to offer Mr. Chaskalson information on Mr. Karim and then fail to deliver because Mr. MOGOTSI turns out doesn't have that kind of information, and then say, I fear that Mr. Chaskalson will be biased against me because I did not give him that which I promised? Isn't there some opportunism there? You offer and then you fail to deliver, and then without more you say he's going to be biased against me. I mean, he hasn't referred us to anything in the chats which shows Mr. Chaskalson being upset with him or saying to him, you know, I'm going to get you for failing to deliver. There's none of that, other than that text which we have read in context, that it actually doesn't quite convey what you were saying, where it says, don't mess with me, don't mess me around or something like that. I don't understand how that an offer made which couldn't be fulfilled without more creates a reasonable, remember the test is reasonable apprehension of bias. How that would create a reasonable apprehension of bias that after this he's not going to treat me fairly.
In response, Commissioner, what we had considered is that Mr. MOGOTSI is the one who called the evidence leader. That is not in dispute. However, what was contained in the phone calls, and I had said previously, I do not know And neither does anybody know what was discussed in these telephone calls.
Then in that case, how can the commission say the apprehension is reasonable if we don't know what was discussed in those calls? You're saying that we don't know, therefore we don't have the content of those telephone calls according to you. So we lack the necessary facts on the basis of which the commission can make the determination that the apprehension is reasonable, because eventually that's what we must find. We must find that the apprehension is reasonable.
Commissioner, firstly, I'll invite the commission to make a finding through what is contained in the papers. Now, what seems to be a challenge is that with regards to the telephone calls, there's a dispute of fact. One says, I said, the other says, I said. Hence, I keep on repeating that I do not know what was contained in the telephone conversation. And Commissioner, you would also not be in a position to know what was discussed in those telephone conversations. And unfortunately for me, there is no recorded conversation of what would have happened. I will rely on the submissions that my client makes before the commission. Now, I had said previously that he's labeled as a liar. He was labeled as a liar. Now, if he approaches you, this liar, and he says, I've got information, why would you be interested in information? He might be lying to you.
I wasn't taking you back to that conversation. I was really addressing your submission where you say, we don't know what was discussed. You don't know, the commissioners don't know what was discussed in those telephone calls. That comes from you, it's your submission. So I was asking the simple question that if we don't have the facts about those calls, what was discussed, are we in a position, at least as it relates to those calls, is the commission in a position to make a determination that what was discussed in the calls creates a reasonable apprehension of bias? That's all I was putting to you. And maybe to reframe it, maybe can I ask you this? Do you accept that for a determination that the bias complaint, the feared bias is reasonable, for that determination, there has to be facts on which that determination is based? Facts must be put to the panel, and then the panel will say, yes, on these facts, we are satisfied or we are not satisfied that the apprehension of bias is reasonable. Do you accept that as a proposition?
I'll accept it, Commissioner.
You accept that?
Yes.
Right. So on the back of that, I then ask the question, if we don't know what was discussed in the calls, insofar as it relates to the calls, limit it to the calls for now. If we do not know what was discussed in those calls, as you say, can you accept, should you not accept that the commission is not, the panel is not in a position to say those telephone calls do create a reasonable apprehension of bias because we don't know what was discussed according to you? Do you accept that we cannot make that determination?
If the Commissioner allows me to reply to that in two parts.
Yes.
On the first aspect, Commissioner, you are correct. In the absence of us knowing or the Commission knowing what was contained in those telephone calls, the Commission cannot rule on the apprehension of harm or of bias.
From the calls, yeah,
Or
just
of
arising
bias,
from
yes,
the
I
calls.
apologize. But then there's two sides and two versions, if I may so put it, of what was contained or what was discussed. And based on those, and based on how the applicant perceives in his mind what the contents of these discussions are, then the commission can be in a position to make a ruling as to whether or not there is an apprehension of bias. Now, Commissioner, I submit further that the issue here is not that Mr. Brown doesn't come back and give testimony in the commission. The issue here is somebody else in the commission may be elected if there's an election procedure or appointed if there's an appointment procedure to come on board and move with the cross-examination.
How much more time do you require, Ms. Mohomane?
On the submissions.
Yes. Your entire submissions. We started at 9:30. Now it is 6 minutes after 12 midday. If I was sitting in the court where I used to sit, we would have given you 30 minutes only. I'm listening. That doesn't mean I will accept the time that you.
Chair, I won't be longer than 5 minutes.
Thank you very much. Thank you.
Chair, lastly, I request to invite the commission to the role of the evidence leaders. I believe I left it hanging, and I had said to the commission that I will come back to it in due course. Now, to supplement what I had said previously, in a nutshell, evidence leaders are required to assist and facilitate the work of the commission. And in doing so, they must investigate and marshal the presentation of evidence to the commission. They bear the overall responsibility of leading evidence before the commission, although it is subject to the direction of the chairperson. If I'm so permitted, may I direct the court to the matter or the ruling by Judge Nugent in the Commission of Inquiry into Tax Administration and Governance by the South African Revenue Service.
You don't need to read that. We have had sight of it. We have read it. Yes. Please continue. But of course, you may make whatever point you want to make about it.
We do not have any further submissions to make unless the commission would like me to address it on other aspects.
No, thank you very much, Ms. Mohomane.
Thank you.
Yes, Ms. Asim.
Thank you, Chair. Chair, I've listened closely to the exchanges between the commissioners and my learned friend, Ms. Mohomane. And to some extent, it covers ground that we had included in the answering affidavit submitted to the Commission, including some of the legal submissions we made there. So I beg the Chair's indulgence if I come back and touch on the same issues that arose in the exchange, but I hope to give it a proper perspective in my address to you. And to begin with, Chair, let me just say that the evidence leaders oppose this application in the strongest terms. And obviously, we submit that the application should be dismissed. And we do so on the basis that it's legally misconceived. And I have heard the shift in approach by my learned friend and the reference to Killian earlier, but I'll submit in due course that that there wasn't actually any shift in an argument and the legal basis, the wrong legal basis that was advanced. So it's legally misconceived. On the facts, it's not just unsustainable, it's a deliberate misrepresentation of the facts. And I propose to return to the facts in order to explain this. And it's an abuse of the Commission's process. Chair, I will address 4 issues. The first, the conceptual flaw. The second is the factual basis of the application. And I would like to have a particular focus on the altered WhatsApp record that was put forward by Mr. MOGOTSI as a key part of the basis, factual basis for his application. Third, the allegation of unfair questioning by Mr. Chaskalson. And finally, what we respectfully submit should be the appropriate ruling in the circumstances, including referrals for investigation for possible perjury, forgery, and contraventions of the Commissions Act and the regulations of this Commission. So the first difficulty, as I said, is conceptual. Mr. MOGOTSI invokes the law of judicial recusal. He relies on Safu, on DeLacy, on Besson, on Burnett, and MOGOTSI. All of those cases concern judicial officers or decision makers. None of them concern a commission of inquiry or even something akin to a commission of inquiry. And while my learned friend indicated reliance on Killian at the start of her submissions to the Commission, she continued to make submissions on the basis of a reasonable apprehension of bias, the test for judicial recusal. And that's not the test that applies, because Mr. Chaskalson is not a decision maker. He doesn't decide credibility. He doesn't decide admissibility. He doesn't make any decisions about whether adverse findings should be made, when and how. Those powers belong to the Commission. What an evidence leader does, as correctly asserted by my learned friend, is an evidence leader assists the Commission. He leads, organizes, and tests evidence. That function must be performed fairly, but it's not adjudicative. It's an investigative function. To assist the Commission, we've provided the authorities that we think are more suited to an application of this sort, where an applicant is seeking to remove an evidence leader. And in this regard, Chair, we refer to the recent ruling of Justice Kampepe in the TRC Commission. And it was specifically an application that was made there too for the recusal of an evidence leader. And what she said is important. The chairperson rejected the proposition that the Safu recusal test applies directly to evidence leaders. Her ruling held that evidence leaders are not decision makers. They function always subject to the direction of the Commission. The appropriate inquiry, therefore, by analogy perhaps with that of prosecutors, is whether the evidence leader's continued role would cause substantive unfairness in the work of the Commission. And that approach is consistent with the decisions in the two cases that we've referred to in the answering submissions, Porritt versus NDPP and DPP Western Cape versus Killian. In Porritt, the Supreme Court of Appeal rejected an attempt to equate prosecutors with judicial officers for the purposes of recusal. And in Killian, the same reasoning was applied. And in Killian, the issue there was whether the prosecutor should be removed because the prosecutor was the same person that had interrogated the applicant for recusal, had interrogated that person in an earlier statutory inquiry. And so there were serious concerns about whether there would be fairness on behalf of the prosecutor in that case, and the Supreme Court of Appeal rejected that argument. So the question is not whether the SARFU recusal test is satisfied, it's whether the continued involvement of the evidence leader would cause substantive unfairness in the Commission's work. Mr. MOGOTSI has not shown that. Now, incidentally,
if the allegations made were true, would the test not be met? I'm not asking whether we should hold that they are. That's a debate we're still engaging in, and that's a finding we will make in the end. But if they were true, would they not meet the test?
Chair, the allegations are so serious. They go to the heart of ethics, professional ethics, and the integrity of the evidence leader. Those kind of allegations, if proven to be correct, would warrant a conclusion that there's unfairness. They're very, very serious allegations, and we take it very seriously. But of course, I'm about to...
It's something else whether
yes.
They are in fact true, and that's what you're going to deal with, and that's what we engage Ms. Mohamani on.
Indeed so, Chair. So, and that rests on the facts that
yes.
support this application.
Yes.
Chair, I actually wanted to say on the law, incidentally, in paragraph 40 of the submissions of the attorney for the Commission, Mr. Mokashwa, paragraph 40, it's pointed out that it's not just that the cases don't apply here because the test doesn't apply. There are quotations that are attributed to those cases which are not found in those cases. I just make it as an aside. For a moment, I thought whether I should even say anything about it, and then I've rethought. And actually, it is important because it is the responsibility of counsel who appear before any tribunal to ensure that the correct law and that is put to a decision maker. And whether or not the papers were settled by the legal representatives were very aware after reading our answering affidavit that was a concern, but it's just not addressed at all. And I just wanted to make that point because one needs to be able to rely on quotations as genuinely existing in the cases that are cited. I leave it at that. I don't want to take it any further. So much for the law and the cases, the legal basis. Mr. MOGOTSI's application. Let's turn to the facts. There are two main factual propositions.
Maybe before you do that, the other point that has been taken and you didn't list it in the topics that you're going to be addressing is the standing of the affidavit of the attorneys for the Commission.
Yes.
And its consequence for Mr. Chaskalson's affidavit.
Yes, thank you, Commissioner. I think that the point is more about form than of substance. Mr. Chaskalson has submitted a full, detailed, comprehensive answering affidavit on oath. it is true that is annexed to Mr. Mogotsi's affidavit, but it's just a question of form, because Mr. Mogotsi sets out submissions, as you will recall, at the end of the last appearance of Mr. Mogotsi. The request was for submissions to be made by the applicant, and then for submissions to be made, including legal submissions, on behalf of the respondent. And it seemed to us, in the unusual circumstances of a commission inquiry, that this would be the appropriate form to submit it in. It's just a question of form. There's nothing that I think it's an entirely unreasonable allegation to make that there's no weight to be given to Mr. Chaskalson's affidavit, because it looks like an annexure and it's not a self-standing affidavit. His position is made very clear. He sets out the facts in his affidavit.
It says in the railway tracks answering affidavit.
And it does,
And
yes.
he says in paragraph 5, I am deposing to an affidavit. So it is an affidavit.
It's absolutely an affidavit, and moreover, he responds in that affidavit, paragraph by paragraph, to the founding affidavit of Mr. Mogotsi.
I think what I understood to be the issue that is raised about it is Mr. Mogotsi lacks locus standi to depose to an affidavit. That's the one part of it. And then the second is his affidavit. Well, it's actually 3 points, as I think I understood them. It's the locus standi issue. And then 2, it is his affidavit contains hearsay. And then the annexure issue that Mr. Chaskalson effectively hasn't answered the allegations because his affidavit is attached as an annexure. So your exchange now with Commissioner Khumalo deals with the third part, which is, well, there is an affidavit that is before us, but the antecedent questions is locus standi, and then the second, I said it was
Hearsay.
hearsay. Thank you.
Well, if one reads the affidavit closely, there isn't hearsay. What one will find in the affidavit is reliance on Mr. Chaskalson's own affidavit for any factual proposition that relates to the communications between Mr. Chaskalson and Mr. Mogotsi. It's a repeated referral to Mr. Chaskalson's affidavit. And where it goes beyond Mr. Chaskalson's affidavit, it does so with reference to the record, transcripts of this commission's hearing.
If we accepted that parts of that affidavit, Mr. Mogotsi's affidavit, contains hearsay, can we disregard that hearsay part of evidence and yet still end up with an affidavit that deals with the other issues that are not an answer to the facts of the exchanges between the two?
Commissioner Beloy, let me have 2 responses to it. The first is, these are different proceedings to a court of law. How you assess the probity of that evidence is up to the commissioners. But hearsay evidence, as we know, is admissible in a commission of inquiry. That's the first thing I'll say. But let me say this too.
Does that not apply to the evidence of witnesses to the commission?
To the extent that Mr.
lower standard of how you treat evidence.
To the extent that Mr. Mogotsi is a witness here in providing this affidavit, then the same would apply. But even if you were to disregard what you may consider to be hearsay, and I'll say again, I'll repeat again to the commission, there's very little hearsay in if any, in that affidavit. But even if there were, and you were to disregard it, the strength of this opposition doesn't rely on Mr. Mogotsi's affidavit. The strength of the opposition relies on Mr. Chaskalson's affidavit.
Is it open to to us, to the commission, to say can we do this? It's a question. We say these paragraphs contain hearsay evidence, which is what is contained in Mr. Chaskalson's testimony anyway, as you say, affidavit. So we disregard Mogotsi to the extent that those parts, because to say it contains hearsay evidence, as I understand the position to be, doesn't mean we necessarily reject the whole affidavit, right? You look at what, in fact, in the affidavit is hearsay, and then you decide how to treat it.
Mm-hmm.
Could we retain Mr. Mogashi's affidavit on the basis that it places Mr. Chaskalson's evidence before us? I don't know if you understand what I'm saying. His affidavit before us, even if we disregarded the parts that we've ultimately say this is hearsay evidence. I don't know if I'm articulating.
I think I understand what you're saying, Commissioner Baloy. I see no reason why you can't do that, even if you were to disregard large parts. And remember that that affidavit doesn't just deal with the facts, it also is here to make submissions. And to make submissions for the purposes of assisting the Commission, which is why we put to the Commission case law that is intended to set the correct legal framework for this. The approach is not to say, well, the applicants didn't make out a case, there's no legal foundation, full stop, which is what one would do in a normal case. You may not necessarily go down a long road. You say there's just no case that's been met here. We're in a different position. We're here to assist the Commission and to put all evidence and all law that may assist the Commissioners in making this decision. And that's the value of that affidavit of Mr. Mogotsi.
And the complaint or assertion that he lacks locus standi, it's accepted that he acts by the applicant, that he acts for the institution. And so I understand the applicant to accept that he has standing to speak on behalf of the Commission, and yet there is a submission that he lacks locus standi. Do you want? I'm not sure I understand how there's an acceptance and yet that kind of complaint. Do you want to say anything about it?
Commissioner Baloy, I have to confess I don't understand the submission. It's very difficult for me to respond to it beyond what I've already said.
Okay. But you assert that Mr. Mogotsi does have locus standi to depose on behalf of the Commission.
And to oppose the application. Yes.
Thank you.
So,
ask a follow-up question. It may or may not matter in the end. My understanding of hearsay is that it is evidence, the probative value of which depends on something which somebody else knows, but that person is not giving evidence. Now, you have a situation here where Mr. Chaskalson deposes to an affidavit which is longer than Mr. Mogashi's affidavit by some 5 or 6 pages. It's 21, Mogashi's is 17. And Mogashi says, I have read Chaskalson's affidavit, so where I deal with the allegations against Chaskalson, I rely on the affidavit by Chaskalson, which means there is an affidavit by Chaskalson. So it's not hearsay because that evidence is here. And he simply repeats then what Chaskalson says.
quite right, Commissioner Kamalo. It really is, as I said, a repeated referral to what is said in Mr. Chaskalson's affidavit.
So if there was no affidavit by Chaskalson, then what Mogasha says would be hearsay?
Absolutely. Absolutely. It's entirely based on Mr. Chaskalson's. And in fact, he says so. Mr. Mogasha says so, that this affidavit is based on the facts, the correct facts as stated in Mr. Chaskalson's affidavit. And so the idea that when I heard my learned friend...
I don't want to, I just wanted that short response.
Sure.
I know we could argue and debate.
We could go on, but I'll turn to the facts then, if I may. So The factual foundation seems to be twofold. First, Mr. MOGOTSI says that Mr. Chaskalson treated him unfairly when he previously testified before this commission, in the manner in which Mr. Chaskalson questioned him. Second, he makes what we say is a very, very grave allegation that Mr. Chaskalson induced him to give evidence and to give false evidence against another witness before this commission. And if one has regard to Mr. Chaskalson's affidavit, it is abundantly clear from the affidavit and the annexures that these propositions are simply untenable. The answering affidavit is more than a denial, and I will call it an answering affidavit, Mr. Chaskalson's affidavit. That's what when I refer to the answering affidavit, I'm always referring to Mr. Chaskalson's affidavit. That affidavit is more than a denial. It's a detailed factual account supported by the true WhatsApp record, annexed as MC1, and a marked up comparison, annexed as MC2, which identifies the communications which Mr. MOGOTSI removed from his annexure, and his annexure is marked OBM2. I think that there was a point at which, when I say that it's more than a denial, there was an argument by my learned friend that Mr. Chaskalson did not dispute paragraph 6.3 of the founding affidavit. And it goes to, there was an exchange between Commissioner Khumalo and my learned friend. It goes to, in fact, if we could just go to Mr. Chaskalson's affidavit at paragraph 17, and that's at page 82 of the record. Because this is the one instance where the submissions for the applicant say that there is no denial by Mr. Chaskalson. And if you look at paragraph 17, so the point that's made is, well, how can Mr. Chaskalson deny that he, solicited evidence from Mr. MOGOTSI if he doesn't recall the conversation? But look closely at what Mr. Chaskalson says at paragraph 17. He says the following: I have no detailed recollection of what was discussed in the call at 20 hours 56 on 9 March 2026, as opposed to the call at 8:03 on the morning of 10 March 2026. So what is set out below is reconstructed from my overall memory of the two calls as informed by the WhatsApp record. What Mr. Chaskalson is saying is I can't say whether I said something in the first call or in the second call, but together, these are the facts that I can set out of the conversations that took place on those two calls. He sets it and then in detail from paragraph 18 and onwards, and he concludes at paragraph 23 with his categorical denials that he invited Mr. MOGOTSI to give false evidence against Mr. Karim, or that he suggested that if Mr. MOGOTSI could find evidence to implicate Mr. Karim, that he would then protect him from adverse findings. So there is simply no basis to say that there's no denial. And again, I submit that it's more than just a denial, because what Mr. Chaskalson does is set out the facts with reference to the WhatsApp record. So calls must be seen in the context of the WhatsApp record. But Mr. MOGOTSI's difficulty goes further, because his own replying affidavit destroys his allegation that Advocate Chaskalson exerted improper pressure on him. He admits to manipulating the WhatsApp exchanges between himself and Mr. Chaskalson before placing the record before the commission. He doesn't use the word manipulating. He tries to explain it in several ways, but he admits to making several deletions. And one deletion he doesn't even answer to at all, and that's the emojis, which I'll come to in a moment. Chair, if I may ask that we look at OBM2, the annexure that's put up by Mr. MOGOTSI, the WhatsApp record that he puts up. OBM2 is, what page?
Reply.
Thank you. I don't know about, I'm not using the bundles because the printed version is not that good for me, for the submissions I'm going to make. I would ask the commissioners, if you have the electronic version, to look at that version, alternatively to look at what's being flighted in front of you, because it's a better version. And it's important that you see this for the following reason. The problem with this annexure is not just about its content and the misrepresentation in the content. It's also about its appearance. It's not presented as a transcript of WhatsApp exchanges that took place between the two individuals with ellipses or anything like that. It's not even presented as screenshots showing deleted messages, as one would ordinarily see in a WhatsApp conversation where messages have been removed. Ordinarily, one sees deleted message, you deleted this message, or this message was deleted. That is not how it appears. It's made to appear as a genuine and complete set of screenshots with the default WhatsApp speech bubble colors and with the default WhatsApp wallpaper. It, in other words, conceals that material texts and calls have been deleted. It's not, if Mr. MOGOTSI had put up a transcript and that indicated there were deletions, that would be one thing. So the first submission I'm making to the commissioners is, before we even get to the content of the deletions, it's the appearance that's created in this constructed set of chats that makes it look like there was nothing in between. And that's significant. The deletions themselves, too, are significant because they are material in what they show and what they don't show. They are material because they point away from the narrative that Mr. MOGOTSI seeks to create before this commission. What he says, of course, to try to explain this is that he admits, first he denies tampering with the WhatsApp messages in paragraph 38, but then he admits to deleting the message. He admits to deleting the message of 12 March at 11:29. And that's the text that says, in fact, if I may ask that MC2 is now displayed, because this shows easily where the deletions are made. So the text said, I'm worried about coming there, also mentioning that I called you at night, thought would be strategic also. He says that this deletion was made to protect the conversation from unnamed third persons. I'm not sure what it is we're supposed to make of that. He says nothing more about these third persons and why there would be a risk. Then he is silent on the text that he deleted with the 3 crying with the laughter emojis. He doesn't explain at all why he deleted those emojis sent on 10 March at 1:18 in the afternoon, and that was during the evidence of Mr. Karim. And what he was indicating was that he was, sort of reveling in the discomfort that Mr. Karim was facing in the witness box. That he deletes, but he doesn't explain why he deleted it. He admits that he deleted the calls. And And he says that he didn't regard them as relevant. So he deleted that from the screenshots, and he wished to capture what he considered to be the relevant facts. But to be clear, what he deleted was 6 calls to Mr. Chaskalson, which Mr. Chaskalson declined to answer. 3 calls on the 9th March, the day on which Mr. Karim first began his evidence, and 3 further calls during the lunch adjournment of Mr. Karim's testimony. He therefore doesn't merely admit to deleting, he admits to curating the WhatsApp account, the WhatsApp record rather, selecting what he considered to be relevant and presenting only part of the picture to the Commission and making it appear authentic. This is deliberately deceptive. This was misleading to the Commission. And Commissioners, Annexure MC2 sets very neatly the actual true content, because what it does is take OBM2 and then it inserts where the missing texts ought to be. And what it also shows is that if this was an authentic record, you would have seen those deletions. You would have seen that it says deleted and it doesn't say so. So those calls, those 6 calls on 9 and 10 March must be understood in the context of the backdrop of Mr. Karim's oral evidence. Because what it shows is, first of all, on 9 March, Mr. Karim gave evidence, right, about his conversations, the WhatsApp conversations that were put in the record between him and Mr. Matlala. As Mr. Chaskalson says in his affidavit, and it's at paragraph 18.2 for the record, that in response to many of the questions that were being put to Mr. Karim regarding the WhatsApp communications between him and Mr. Matlala, Mr. Karim sought to blame Mr. MOGOTSI for what he was conveying to Mr. Matlala. So that was what was happening on the 9th of March. That evening, Mr. MOGOTSI initiated a call to Mr. Chaskalson. Mr. Chaskalson says, and that's at paragraph 19 of his affidavit for the record, that in his call, which lasted all of 3 minutes, in this call, Mr. MOGOTSI conveyed his concern that Mr. Karim had been blaming him for everything. Mr. Chaskalson accepts that he agreed with this assessment. That too was his assessment of Mr. Karim's evidence. And he also accepts that he may well have used the phrase throwing him under the bus. And he refers to, he puts up the contemporaneous text to 2 investigators of the Commission where he used that phrase, and speaking colloquially, he used the phrase throwing him under the bus. But it's Mr. MOGOTSI who asks, how will you protect me? Mr. Chaskalson explains this at paragraph 24 of his affidavit for the record, that he understood Mr. MOGOTSI to be asking for protection from being falsely blamed. So protection from being thrown under the bus. That's the protection that he understood Mr. MOGOTSI to be seeking. That's his explanation of it. Mr. MOGOTSI then called 3 more times that night. Mr. Chaskalson did not answer. So it's Mr. MOGOTSI that's driving this. The pursuit is being made by Mr. MOGOTSI, not by Mr. Chaskalson. What Mr. Chaskalson says is that Mr. MOGOTSI offered evidence against Mr. Karim, as well as further evidence. So it wasn't just evidence regarding Mr. Karim's testimony, but it was also evidence relating to the Medicare 24 contract that was also a subject of debate with Mr. Karim, the contract that Mr. Matlala concluded with the SAPS. And again, that explanation is corroborated by the two contemporaneous messages to the two investigators. Because when you have a look at that, those are annexed as MC4 and MC5 to Mr. Chaskelson's answering affidavit. What he says in those texts to the investigators in part is, MOGOTSI has been calling me non-stop. He wants to give us dirt on Karim and ostensibly wants to tell us what he knows about Matlala's contract. And then he asks the investigators to join him in a meeting with the Mr. MOGOTSI that he was trying to set up the next day at 10 o'clock. They both agreed to go through to the meeting. And the plan was to go through to hear what Mr. MOGOTSI had to say, obviously, but to go through his evidence because, again, Commissioners, you may recall that Mr. MOGOTSI was due to appear before the Commission on the 13th of March. He was no longer represented. Therefore, Mr. Chaskalson needed to meet with him in order to make sure that there was preparation for that evidence on the 13th of March. It's entirely appropriate that Mr. Chaskalson did so. So the continued allegations that, well, he was trying to meet me really is neither here nor there. There's simply nothing wrong with Mr. Chaskalson making those efforts. But Mr. MOGOTSI doesn't show up to the meeting at 10 o'clock, and he doesn't he doesn't give any indication that he's not going to show up. So then when Mr. Chaskalson calls him, the call is again very short if one has a look at the record, and it's to inquire about his whereabouts. They then agree that they'll meet at 2 o'clock. And they set an appointment for 2 o'clock, and again, Mr. MOGOTSI doesn't show up. And again, Mr. MOGOTSI doesn't answer his phone, and he doesn't explain why he didn't show up. He doesn't give an indication. In the meantime, we've had Mr. Chaskalson and the investigators waiting around for this appointment. And that's what Mr. Chaskalson explains when he says what he meant by, you can't mess me around. That's what he says, is you can't mess me around. And he explains that what he's referring to is that Mr. MOGOTSI's missing appointments was continually missing these appointments and disrupting the schedules of the evidence leader and the investigators. So that's his explanation. Don't mess me around. And makes sense when you have regard to the full context of the WhatsApp records. If you were truly, and I think it was, I can't remember which of the commissioners put this to my learned friend, but the point is important because if he were truly attempting to use false information against Mr. MOGOTSI, why would he invite the investigators to accompany him? And second important relevance of the investigators being there is so that they can follow up on any information that does emerge from Mr. MOGOTSI to test its credibility and to see whether it can be independently corroborated. Again, entirely consistent with the version that Mr. Chaskalson explains in his answering affidavit. So the true picture is this. Mr. MOGOTSI pursued Mr. Chaskalson. He initiated the conversations. He says he was concerned that Mr. Karim was throwing him under the bus. He sought assistance to avoid being used as a scapegoat, as Mr. Chaskalson explains it. That was his understanding, that's the assistance, the help he wanted was not to be used as a scapegoat. And then he offered to provide evidence against Mr. Karim and the Medicare 24 contract. But what is more, as we now know, he was also peddling falsehoods to Mr. Chaskalson. And he says so in order to precipitate a postponement of Mr. Karim's evidence. And we also see now, contrary to everything that he was saying about Mr. Karim to Mr. Chaskalson around the 9th and 10th of March, when those efforts proved unsuccessful to provide evidence to secure a postponement, he then provides an affidavit which is attached to his founding affidavit in which he lists all the parts of the testimony that of Mr. Karim that he now corroborates. And I'll come back to the false information, Chair. Let me deal with the next aspect before I come to that. The next aspect is this question of, well, you see Mr. Chaskalson was playing this false game, because on the 10th of March, when he was questioning Mr. Karim, he said to Mr. Karim that yesterday Mr. MOGOTSI told me this about a meeting that took place in the Northwest. And I really am not going to spend much time on this. It's very clear when you look at the record that what Mr. Chaskalson was saying was, he said the following: because after your evidence yesterday, Mr. MOGOTSI called us up. So he was referring to evidence that had been given the day before, not that Mr. MOGOTSI had called him the day before. So the timing of the call from Mr. MOGOTSI is actually not relevant. The material point is this. It's that Mr. MOGOTSI admits that he told Mr. Chaskalson that this meeting took place, this meeting in the Northwest. He admits that. And then he adds this following startling addition to his affidavit. At paragraph 6.10 of his founding affidavit, he says the following. He says, I began by suggesting he asked about the meeting between myself, Morgan Maumela, and Suleiman. A meeting which never took place. I did this deliberately to encourage him to postpone Suleiman's testimony, as I was already concerned about the Commission's treatment of me and its focus on issues outside its mandate. So this is the point I was making earlier. He admits that what he told Mr. Chaskalson was false in that paragraph, and that he advanced that falsehood to secure postponement of Mr. Karim's testimony. That admission is serious, because it's not just, it doesn't only suggest dishonesty, but it's a deliberate attempt to manipulate the evidence leader and this Commission's process. Mr. MOGOTSI's conduct, and it's for that reason, Chair, that we say that Mr. MOGOTSI's conduct, in addition to the forged WhatsApp record, his conduct should be investigated as a possible offence under the Section 5 of the Commissions Act and Regulation.
6.20 says, I deliberately mentioned it to prompt a postponement of Suleiman's testimony, so it was deliberate.
Absolutely. He deliberately gave false evidence to secure the postponement of Mr. Karim's evidence. Those are the words that he says unmistakably in his affidavit. That brings me to the complaint about the questioning. Mr. MOGOTSI complains that Mr. Chaskalson questioned him very vigorously and put it to him that he was dishonest. That's true. That did take place. Mr. Chaskalson did question him vigorously and did say to him that he was being dishonest. But that's not unfair, because a commission is inquisitorial. It's the duty of an evidence leader to test evidence, to confront witnesses with inconsistencies, and to put adverse propositions to them so that they may answer. Robust questioning is not unfairness. In our affidavit, in our submissions, we pointed to the extract from Justice Nugent's ruling in the SARS Commission, where he speaks about the role of evidence leaders. Chair, I do think that this paragraph is important. May I read it out? And I think it's important that everybody understands the role of evidence leaders. And I'll read it very fast. What Justice Nugent said in the SARS Commission is the following. What is called for from counsel for a commission and from the commission itself is an open but inquiring mind, the meaning of which I had occasion to explain in the Supreme Court of Appeal. That case concerned the functions of the public protector, but it applies as much to a commission of inquiry. And then he quotes from the SCA judgment as follows. That state of mind is one that is open to all possibilities and reflects upon whether the truth has been told. It is not one that is unduly suspicious, but it's also not one that is unduly believing. It asks whether the pieces that have been presented fit into place. If at first they do not, then it asks questions and seeks out information until they do. It's also not a state of mind that remains static. If the pieces remain out of place after further inquiry, then it might progress to being a suspicious mind. And if the pieces still do not fit, then it might progress to a conviction that there is deceit. How it progresses will vary with the exigencies of the particular case. One question might lead to another, and that question to yet another, and so it might go on. It is in that state of mind that counsel go about their work. So that the SCA, for completeness, the SCA judgment that Justice Nugent was referring to was a passage from the Public Protector versus Mail and Guardian. And the reference, if I may provide it, is 2011, Volume 4, South African Law Reports, at page 420, decision of the SCA, and the passage is in paragraph 22 of the judgment.
Is the citation not given in the affidavit?
It is not.
It is not.
No, it is not, Chair. That's why I'm giving it to you now. We omitted to explain that that's where the passage comes from. The Constitutional Court cited the same principle with approval. The same paragraph 22 was cited by the Con Court with approval in Public Protector versus the President of the Republic of South Africa. And again, for completeness, let me provide that citation. It's 2021, Volume 6, South African Law Reports, page 37, decision of the Con Court, and it's at paragraph 139 specifically. That's the proper approach to questioning by an evidence leader. It does not require impartiality. It requires a probing, open, inquiring, probing mind. There's also an important practical fact to make about the questioning, Chair, that took place. And this was in November 2025. When Mr. MOGOTSI testified then, he was legally represented. His legal representatives did not object to the questions that are now being complained of, the questioning. The complaint is only raised later when the witness is due to return to the witness box. And I'd submit that that timing is telling.
But of course, the lack of objection is not in and of itself determinative.
That's correct. That's correct, Chair. But one would think that if the degree to which Mr. MOGOTSI is complaining now about it, that if it was that serious at the time, that there would have been a complaint at the time. There wasn't. But we have addressed the complaint nevertheless, because one ought to still address the substance of the complaint. Correct, Chair. There's one additional point which I didn't indicate in my opening, but it's about, and it came up again in the questions, it's about ignoring leads that are relevant, information that's provided, that's ignored. And what Mr. MOGOTSI says is that he provided certain leads and they were not pursued. First of all, that's not a recusal point. The Commission is assisted by evidence leaders and investigators. The evidence leaders and the investigators decide what to investigate, when to investigate it, through which witnesses, and whether something warrants investigation. A witness who provides information does not acquire a right to dictate the Commission's investigative priorities. So failure to pursue a witness's preferred leads immediately does not establish bias. There may be many reasons, but Chair, in the Mr. Mogoshi's affidavit, he does deal with this complaint and what one sees.
I noticed that you too fall into the trap of bias instead of substantive unfairness.
Absolutely. Well, it doesn't even establish bias, let alone substantive unfairness. So on their test, it doesn't even meet the grade. There was the Section 252 information. There was the crime intelligence procurement information, and so on, and that's addressed fully in the affidavit. In fact, the Section 252 investigation was thoroughly questioned and probed during Mr. Mogotsi's evidence, and we've attached the entire transcript, which is why this is bulkier than it should be, is because we've attached the transcript to show in the many different places in which that lead was tested and questioned. We are not at liberty, and nor are we required to say how else we are pursuing these leads and these investigations and the other witnesses who have come to testify here, including those who may have come in camera. And that's where I'm going to leave it. It's just not a witness's...
The test with regard to those leads would have to be how, if at all, does the fact that they have not been dealt with, how does that impact on the retention of the evidence leader, with the result that there would be substantive unfairness? That is what Mr. Mogotsi would have to show, and I'm not aware that there has been any attempt to show that at all with regard to those leads.
Chair, there's nothing in the affidavit that suggests that it therefore is going to mean that Mr. Mogotsi is being treated unfairly. Maybe it will be to the detriment of the commission. It won't have a full picture if those leads are not pursued, or something at best. And there are many reasons for when and how evidence is placed before the commission. Some leads require further corroboration, further witnesses, etc. All of that is entirely separate to the questioning of Mr. Mogotsi and whether Mr. Chaskalson can continue to question him. And whether there'd be any unfairness in that.
Yeah. Yes, please continue.
The final point before I conclude, Commissioners, is that the timing of the application does matter, because the questions that are complained of go back to 2025, and then the WhatsApp complaint starts in 9 and 10 March. But the application is only brought when Mr. Mogotsi is due to return to give evidence. And the reason I'm raising this again, this issue of the delays, for two reasons. The first is a practical one about protecting the Commission's proceedings. And in fact, in Burnett, the case that's put up by the applicant, the only aspect of this case that's of any relevance to this application, in fact, when it doesn't help the applicants, is at paragraph 71, where the court says the following about complaints of, when complaints of reasonable apprehension of bias should be made. And the court says this, the Constitutional Court, it is highly desirable if extra costs, delay, and inconvenience are to be avoided, that complaints of this nature be raised at the earliest possible stage. So I raise it for that point. It's a practical point, and it's about protecting the Commission's resources, time, and its proceedings. The second is, what I submit with respect, is that properly understood, what it shows is that this application is just another stratagem to manufacture further objections, to secure further postponements, and to ultimately avoid testifying before the Commission. So for those two submissions, I say that the delay is relevant. So in conclusion, Chair, let me finally submit that the application should be dismissed. And we submit with respect, that the Commission should find that there is no legal basis that's set for a recusal of an evidence leader, as if he were a judge or a decision maker, that the applicable inquiry is whether continued involvement would cause substantive unfairness, that Mr. MOGOTSI has not established any such unfairness, that the allegation that Mr. Chaskalson has induced false evidence is unsupported and is contradicted by Mr. MOGOTSI's own submissions, and in my own personal opinion is a reckless and slanderous allegation, but that's my own personal opinion. Mr. MOGOTSI placed before the Commission a materially incomplete WhatsApp record and admitted to deleting material from it. He should therefore be referred to investigation for possible perjury, forgery, and contraventions of Section 5 of the Commissions Act and Regulation 12.1 of this Commission's regulations. And thus, in short, Chair, if the Commission were to rule that this application falls to be dismissed, we would finally say that then what must appropriately follow is that the Commission directs that Mr. MOGOTSI's evidence proceeds without further delay. And of course, the appropriate evidence leader would be Mr. Chaskalson. Thank you, Chair.
Thank you, Ms. Hazim. Yes, Ms. Mohumane. Oh, your mic, please.
I apologize, Chair. Thank you. I see that it's lunchtime. I'm uncertain if Chair
Our preference is for you to reply, but not more than 10 minutes.
I'll confine myself to the 10 minutes, Chair.
Yes.
Thank you. Thank you, Chair. In reply, I will start firstly by talking about the deleted calls. What is shown in the MC2, which is the WhatsApp chat of Mr. Chaskalson, it's that these are missed calls. And Mr. MOGOTSI further says that he deleted them in his WhatsApp because they were missed calls and he saw no significance in having them. Now, further, Annexure MC2, which will be Mr. Chaskalson's WhatsApp, which is the WhatsApp that comes without any calls or emojis being deleted. The first page, which depicts the 9th of March 2026, it will be page 35. Chair, what I want to submit is that if the Commission looks right on top of the chat, there's a word there that says nose. And there's a time that says 8:56 a.m. Now, Chair, with that, my submission is that even Mr. Chaskalson has not brought the entire conversation between himself and Mr. MOGOTSI. With that little that appears, it's evident that there's been some discussions prior to the one of the 9th. Now, Chair, my submission with regards to that is it prompts that messages that come prior to that, which are conversations between Mr. MOGOTSI and Mr. Chaskalson, also be looked at. Because there's nowhere in the affidavits, both of the applicant and that of the first respondent, that makes reference or gives the Commission an explanation as to what was discussed prior to the stage of the 9th.
But Mr. MOGOTSI is the applicant and is the one who's suggesting impropriety if by the lack of text or the fullness of text in this regard, you want to make some point with regard to impropriety, is it not so that as the applicant, Mr. MOGOTSI, should have told us what's happening there?
It's true, Chair,
Yes,
but then
yes, yes.
it takes away this impression that has been created that Mr. MOGOTSI is the one who reached out to the evidence leader, and this happened on the 9th.
But don't the calls that I referred you to earlier show that it is he who appears to have reached out? And in addition to that, I think Commissioner Baloyi took you to the detail of what actually happened, and also lack of denials by Mr. MOGOTSI in his replying affidavit with regard to who actually initiated all of this. So your point cannot stand. Do you remember that engagement by Commissioner Baloyi?
Yes, I
And when Commissioner Baloyi made specific reference to what is lacking in the replying affidavit with regard to allegations made by the chief evidence leader. So I don't see how you can make the point you are now attempting to make.
Your chairman
Can I just add to that before you answer based on your instructions? In the founding affidavit, that the whole of paragraph 6, it sets out the heading is detailed factual basis for application, and Mr. MOGOTSI speaks only to the 9th and 10th. So those are the relevant facts, that what he says are the relevant facts for purposes of this application. And if you look at that WhatsApp message that you are relying on MC2, the first call is on the 9th of March, is at 8:56 p.m. Can you see that? Because this thing has got dates on it when communication started. So you've got two things. On Mr. MOGOTSI's facts that he relies on for this application, he selected the 9th and 10th to speak to. And then the WhatsApp that you've referred to, in fact, records what happens between them from the 9th. So what happened on the 8th, Mr. MOGOTSI didn't consider it to be relevant. He hasn't placed it before us.
In addition,
Yeah.
In addition, look at 6.3. There is specific reference to 20H56, and indeed you do see the 3-minute call at 8:56. So Mr. Chaskalson's focus is there or relates to that timeline. So that's why his focus and additions of what are missing from Mr. MOGOTSI's chats focus on that timeline. So you cannot fault Mr. Chaskalson by not saying anything about the nose at the top, appearing at the top. That would be very unfair. His attention has been drawn to 8:56, and then he focuses on that timeline. Do you follow what I'm saying?
I do follow, Chair.
Yes. Can you continue with your submissions then?
Chair, further, there was an issue that was raised by the second respondent regarding the contents of Mr. MOGOTSI's affidavit with a further postponement when Mr. Karim was giving testimony.
6.10 on page 14 and 6.20 on page 17. Because I had a question there also. What should we make of that? if Mr. MOGOTSI himself says, I gave Mr. Chaskalson this information in order to engineer a postponement of Mr. Karim's evidence, because that is serious interference with the work of the commission. If you are giving evidence leaders misleading information and your intention is to engineer a postponement of a witness who's in the witness box and giving evidence. So as you deal with that point, can you please address that?
Will do so, Commissioner. In reply to 6.10, read together with 6.11, these are events that transpire whilst Mr. MOGOTSI is trying to get information or whatever evidence that the evidence leader can use. And now my submission on that is that he mentioned the health department tender, which is contained in paragraph 6.11. And he also mentioned Mr. Maumela and Suleiman in paragraph 10, hoping that in light of this information, he might go and get an opportunity to get more information that was required from him, from the evidence leader. That is how I understand this.
So he doesn't say that. He says, I did this deliberately to encourage him to postpone Suleiman's testimony, as I was already concerned about the commission's treatment of me and its focus on issues outside its mandate. He does give a reason why he engineered that. He was trying to engineer postponement in favor of Mr. Karim.
Ms. Momani, look at 6.10. He says, he began by suggesting that Mr. Chaskalson should ask Mr. Karim about a meeting that took place between himself, Maumela, and Suleiman. And then he says that meeting never took place. So he lied when he said there was such a meeting. And then he says, I did this deliberately to encourage him to postpone Suleiman's testimony.
And he further, Commissioner, says, as I was already concerned about the Commission's treatment of me and its focus on issues outside its mandate.
Yes, so my issue is, why would he mislead the evidence leader about a meeting that never took place, and him saying under oath that he did so in order to engineer the postponement of Mr. Karim's testimony?
The answer to that question, Commissioner, it's on the last two lines of that paragraph. He says he was concerned about the Commission's treatment and the focus on issues outside its mandate.
So I'm going to leave it at, you believe that him misleading evidence leaders to engineer a postponement of another witness is justifiable if he's concerned about his own treatment?
That is not my comment, Chair, and that is not my belief. I'm merely directing the Commissioner to say that in that same paragraph, he gives an explanation to say that he was concerned about the Commission's treatment and its focus. I'm mindful not to be found to say that his concern was correct about making mention of a meeting. I'm just merely emphasizing that he states that this is the reason he did it. It is not my opinion as to whether it is right or not.
I appreciate that. Thank you.
So we are dealing with a witness who will say or do anything based on what he wants. It doesn't matter if that may be untrue. Effectively, that is what is happening here, or not? Yes. Do you agree with me? I think you must. You must.
In response to the question, firstly, I'll respond by saying it's improper.
Do you
And it-
agree with the proposition I've put to you? I'm not asking about, that's not the question. The impropriety, if I am correct, is obvious, so that's not where I am. Do you agree with the proposition I put to you?
Can Chair repeat the proposition again?
I say, based on what the witness is saying here, we are dealing with a witness who will say or do anything, regardless of its truthfulness or lack of it, depending on what he wants under the circumstances. That's the sort of witness we are dealing with, based on what we read here. Do you agree? You must.
Chair, may I answer it in twofold, Chair? Yes, I agree.
Thank you.
And if Chair permits me, may I?
Can I ask my next question before
Yes,
you
Chair.
go there? You may go afterwards.
Yes, Chair.
So if that's the sort of witness we are dealing with here, what must we make of that in the broader scheme of things? And by that, I mean with regard to this application. I'm not talking about Mr. MOGOTSI's testimony with regard to the investigative process. What must we do with that, or what must we make of that in the context of this application?
Earlier during the proceedings, Chair made an example about a father and a child. And Chair said that a man of value, a staunch father, would know what he had uttered and why he didn't utter. And Chair will understand where I'm going with
I
that
don't.
example.
I
I'll
honestly
explain it so
don't.
that Chair
Okay,
understands.
Okay.
A child in a house who lives with very strict parents and he gets a good beating when he does something. Even if he hadn't done it, to avoid getting a good beating, he would simply say, yes, Dad, I did it. Now, why that example, Chair? We have Mr. MOGOTSI, who, according to his papers, believe that if he doesn't deliver, as per the agreement, consequences are going to befall him. Now, if consequences befall him, there'll be adverse consequences. He then turned into this.
I'm not sure I follow that in the context of Mr. MOGOTSI saying, I did this deliberately to encourage him to postpone Suleiman's testimony.
It's
So
to run
I don't see.
It's
the
to run
relevance.
away, Chair, from the consequences. The consequences that he
So
feared.
basically, you are explaining why he lied. Is that what you are saying?
Chair, in light of what is contained in the paper,
Are you explaining why he lied?
from what is in the papers, yes, Chair.
Yes. Now, that takes me back to my question, which is, so if we have a witness like that, what must we make of such a witness in the context of this application, this interlocutory application? That's my question.
Chair, that leaves the Commission with nothing other than to find on the credibility of the applicant.
Please, I think the 10 minutes is...
It has, beloved Chair. Can I just see for a second, Chair, if there's any other thing
Yes.
I wanted to address?
All right.
Just one aspect. Oh, sorry, Chair. I apologize, Chair.
Please continue, Ms. Mohammed.
Thank you, Chair. On just one aspect, the timing of the filing of the application. Chair, it's common cause that Mr. MOGOTSI did not have attorneys from, I think, January of 2026. And according to the letters that were filed in the commission, my attorney only came on record, I believe it was during the Easter holidays. I do not recall the exact date. Now, from the time he came in to consulting and raising these issues, it still falls within a reasonable time. And
On my reading, I don't remember reading that explanation in the affidavit. Is it there in the reply?
no, it's not in the replying affidavit. It's merely,
Should it not have been there? You know what judges will usually throw at counsel, which is counsel are now testifying from the bar.
I'll retract that submission. I have
Indeed.
nothing further to say, Chair.
Thank you very much, Ms. Mohammed. Let's adjourn and resume at 2:30.